Good afternoon. Your name, sir?
David Walker.
Your Honor, it looks like he has two files.
I see that. All right, we'll next take up two cases, both entitled State of Kansas versus David Wayne Walker, 22 CR 398 and 22 CR 508. All right, we'll first take up 22 CR 508. This is my case, Mr. Walker. You failed to appear in front of me on July 17th for your preliminary hearing control docket. Where were you that day?
All right, guys, buckle up because today's courtroom is a wild ride. We've got a sovereign citizen who might just take the title of most confused defendant ever. From missed court appearances to self-representation chaos, this guy is about to make life as hard as possible for himself. But don't let the humor fool you. This is serious business, with multiple felony charges on the line. Over the next few minutes, we're breaking down every ridiculous, frustrating, and jaw-dropping moment. Stay with me because the twists in this case are as insane as they are educational. And trust me, you'll want to see how this ends.
And set a new bond in the amount of $10,000 cash or surety. Are you still representing yourself?
Yes, sir.
You want to continue representing yourself?
Look at me. I'm not looking at you. I'm looking at the paper. Yes, sir. Don't have any money to.
Pardon?
Yes, I guess I represent myself.
Okay. You understand that if you can't afford to hire an attorney, one would be appointed for you.
I don't know what he would do for me.
So here's where it gets interesting. Mr. Walker has failed to appear multiple times, which automatically triggers a bench warrant and bond forfeiture. The judge doesn't sugarcoat it. There's a new $10,000 cash or surety bond, and he's still insisting on representing himself. Now, let's be clear, self-representation is a constitutional right, but in cases like this, it's almost always a disaster waiting to happen. The judge is walking him through what an attorney could do that he can't. Legal advice, defense strategies, potential charge adductions. But our confused citizen thinks he knows better. Audience, let me ask you, do you think self-representation is ever a smart move in a felony case, or is this just pure hubris?
Okay. Well, he could provide you legal advice and perhaps advance any defenses you may have had, but if you want to represent yourself, you have that right. I just want to make sure you understand that if you can't afford an attorney and would like to have one represented you, I would appoint one for you. Do you understand that?
Yes, sir.
And you wish to continue representing yourself?
Yes, sir.
The docket notes don't reflect if a waiver of counsel was ever signed. Do you have any notes that would reflect that he's waived counsel on the record or otherwise, Ms. Norris?
Your Honor, I just note that on December 30th of 2022, defendant stated that he would hire his own counsel.
Here comes the classic sovereign citizen argument. There's no victim. But this is where the law gets tricky. Even if no individual person was directly harmed, the state, the people, is considered the victim. And with charges like possession of methamphetamine or driving while suspended, the risk to public safety is real. The judge gives a perfect example. Speeding 100 miles per hour through a school zone. 364 days you may not hurt anyone, but on that 365th day, someone could. Laws exist to prevent that worst case scenario, and the courtroom is laying down the reality check hard. This is the kind of clarity you wish every defendant understood before playing games with the system.
And then he had a failure to appear. And on May 5th, we did not appoint any counsel. I don't show an actual waiver. And the notes don't reflect that he did a waiver on the record. It just says that he would hire his own attorney.
Okay. Well, Mr. Walker, you've indicated here on the record that you wish to waive your right to an attorney and represent yourself. So I'm going to have you, if the jail has one, sign a waiver of counsel. Do you have a form?
I believe so.
All right. Can you read through that? Make sure you understand it. If you have any questions, be sure to ask me.
There's
Yeah.
no defendant in the, and I'm the defendant in the case.
Now watch the tension escalate. Mr. Walker is hesitant to sign the waiver counsel. You can almost see the gears turning. Why sign this? Why do I need a lawyer? The judge has to pause, explain that this is just documentation to ensure he knows his rights. And let's be real, this is peak courtroom frustration. The audience sees the absurdity. The defendant sees paperwork he thinks is unnecessary. Meanwhile, the judge stays calm but firm, reinforcing that this isn't optional. It's procedural necessity. It's moments like this that reveal the clash between legal reality and sovereign citizen ideology, and it's both maddening and fascinating to watch.
There's no victim. There's no victim to my crime, correct? The crime that I'm accused of, there is no victim in the crime.
The state of Kansas, you have drug charges, possession of methamphetamine, possession of paraphernalia, and driving while suspended are your 3 charges.
Yeah, but no victim, correct? No victim in the crime.
I'm not sure I understand your question and what that has to do with your waiver of counsel.
Well, I'm the defendant. There must be someone making a claim that
The state of Kansas is making the charges against you, Mr. Walker.
the state of Kansas is the victim.
The state of Kansas charged you with these crimes. Do you wish to represent yourself, or do you wish to have an attorney representing you?
Next up, bond and scheduling details. Judge Webster's case is also on deck, and Mr. Walker has a $6,000 bond here. Both hearings are set via Zoom, which is the new normal in many courts, but might confuse someone used to in-person appearances. The judge carefully lays out dates, times, and bond requirements, clear, precise, and non-negotiable. The drama here isn't explosive, but the underlying tension is all about control and responsibility. Our defendant struggles with the concept of authority, paperwork, and deadlines, which is a perfect storm for continued legal trouble. It's a reminder, in court, clarity and compliance are everything, and missing a detail can cost thousands.
Why do I need to sign? Why do I need to sign it? Why do I need to sign this?
Because I like to have it documented in the file that you understand that you have a right to have an attorney representing you, and that if you can't afford to hire one, one would be appointed for you. And you understand that, and knowing those rights, you wish to represent yourself. That just documents that for the court file.
What I don't understand is why there is charges against me when there is no victim.
All right, Mr. Walker, I'm not going to play this game this afternoon. I'm going to set this case
Why are we playing a game?
in front of me on
I'm asking questions. I'm really asking questions.
October.
And here's a comedic beat. The judge says recess, and you just know Mr. Walker is picturing a playground. This is exactly why courtroom commentary is gold. You get moments of pure absurdity alongside serious legal lessons. While it's easy to laugh, remember, behind the humor is real-world consequence. Every time the defendant misinterprets a term or process, his legal jeopardy increases. Courtroom reality bites, even for the most clueless. And for you viewers, it's a great reminder. The law is precise, and ignorance, no matter how funny, doesn't excuse you from it.
And that will be done by Zoom. That's the felony preliminary hearing control docket, October 10th at 2:30.
Your Honor.
You've got a $10,000 cash or surety bond on that case.
Yeah. I was wondering if I would be if I wouldn't be able to have access to certain legal things to
I'm not sure what kind of access they provide to you, but you can consult with somebody there at the jail.
okay.
All right, I'm now going to take up 22 CR 398. This is Judge Webster's case.
So, what do we take from this whirlwind? Multiple charges, repeated failures to appear, and a stubborn self-representation strategy. Mr. Walker's choices have made his legal life infinitely harder, and the judge has been meticulous, patient, and professional throughout. This is a textbook example of how legal processes aren't just bureaucratic. They exist to protect the system, the public, and yes, even the defendant in the long run. For those watching, it's a fascinating mix of chaos, confusion, and courtroom procedure, showing why representation matters and why understanding the law is critical.
Looks like you failed to appear in front of her on July 31st. She set a new bond for $6,000 cash or surety. You've already had a first appearance, so I'm going to set this in front of Judge Webster on October 30th at 9 o'clock in the morning. That will be by Zoom, October 30th at 9 o'clock in the morning. So again, your bond is $6,000 cash or surety. Anything else on this case, Ms. Norris?
No, Your Honor, thank you.
Your Honor, was the time for court on October 10th for 22 CR 508, was that 2:30?
That's correct.
Just clarifying. Thank you, Your Honor.
To wrap up, today's case highlights the clash between sovereign citizen ideology and real-world law. Mr. Walker faces serious charges, multiple bond requirements, and a reality that self-representation can only get you so far. The judges handled this with professionalism, clarity, and patience, making sure every procedural step was followed. If you found this case as shocking as we did, hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping breakdowns. Courtroom drama, legal lesson, and moments of pure absurdity. You won't want to miss what's coming next.